Did you know that thousands of people living in Australia could be forced to leave the country in 2026, even if they've done nothing wrong? That's right. New deportation laws are being implemented that could tear apart families, disrupt careers, and change the lives of many without warning. It's not just criminals or dangerous individuals who are at risk. You might be affected too, even if you're just an everyday resident or a student. But here's the shocking part. Minor offenses could now lead to deportation. From shoplifting to overstaying a visa by a few days, the line between staying and being sent home has never been blurrier. You won't believe who's actually being targeted by these changes, and it's more than just the typical suspects. Stick with us until the end of this video because we're about to reveal the 10 most unexpected ways these new laws could impact you, your family, or someone you know. Stay tuned, you won't want to miss this. Number 1. New criteria for deportation. The 2026 changes to Australia's deportation laws introduce stricter criteria than ever before. It's not just serious criminal offenses that could land someone in hot water, but also a pattern of minor offenses. Even something as small as repeatedly failing to pay fines or minor traffic violations can now put you at risk. These changes mark a shift in policy where the government is prioritizing public safety and immigration control. But while the intent may be to protect the country, it casts a wider net than ever before, potentially affecting thousands of ordinary residents who once thought they were safe. The new criteria make it clear that deportation can now follow a criminal charge, regardless of how serious or minor the offense might seem. For example, if someone is convicted for things like repeated shoplifting, they may face deportation. This doesn't just apply to new immigrants, but to permanent residents who've been living in the country for years. The law's being applied to anyone who's legally in the country, and the goal seems to be making the immigration process tougher and more accountable. This change eliminates any room for error in a way that can leave many people unprepared. So, what does this mean for you or someone you know? Everyone needs to be aware of the potential consequences of a minor slip-up, no matter how long they've been in Australia. It's crucial to understand how these laws could affect not just foreign nationals, but also those who have spent a large part of their lives contributing to the country. It's time to pay attention because one small mistake might lead to a life-changing consequence. Do you think these new deportation rules are fair? Drop your thoughts in the comments below. We put a lot of effort into these videos and would love to hear your opinion. Also, make sure to subscribe. It's just one click to stay updated on critical information like this. Number 2. Deportation of permanent residents with minor offenses. Under the new laws, permanent residents who once enjoyed a relatively secure status in Australia are now at risk of being deported for minor offenses. This means that even people who have lived in the country for years, contributed to society, and built their lives here could be forced to leave due to something as small as a traffic violation or an unpaid fine. The shift in the legal framework is raising eyebrows because it essentially redefines what qualifies as a serious enough offense to warrant deportation. In the past, deportation was typically reserved for those convicted of serious crimes, such as violent offenses or drug trafficking. But now, repeated minor infractions could trigger deportation proceedings. This change is controversial because it challenges the traditional understanding of justice and the protection that permanent residents were once afforded. The law is being seen as a way to enforce stricter immigration control, but it also risks affecting those who may not even realize they are in violation of the law. For example, someone who has accumulated fines for jaywalking or parking tickets could now find themselves facing the unimaginable consequence of losing their right to stay in Australia. It's essential for permanent residents to understand that they are not immune. If you've been living in Australia for years and think you're safe, think again. These new laws show that even the most trivial of mistakes can lead to drastic consequences. This could affect your family, your career, and your future. Understanding the details of these laws could make all the difference in protecting your rights and ensuring your stay in Australia is uninterrupted. Do you think permanent residents should face deportation for minor offenses? We'd love to hear your thoughts. Leave a comment below. Your opinion really matters to us. Don't forget to subscribe for more essential updates. It's just one click. Number 3. Impact on families of offenders. The new deportation laws don't just affect individuals, they can have a devastating impact on families. Imagine being a parent in Australia, raising children who were born in the country, when suddenly you're told that you must leave. Under these laws, families can be torn apart, with parents deported while their children, who are Australian citizens, are forced to stay behind. This scenario is becoming a real possibility for many families who find themselves caught in the crossfire of a legal system that prioritizes immigration enforcement over family unity. For families, the emotional toll of deportation can be overwhelming. The new rules create a heart-wrenching dilemma. Should parents choose to stay with their children and face legal consequences, or should they leave the country to avoid deportation, risking the separation from their loved ones? The law's disregard for family unity has raised alarms among advocates who argue that the consequences of these new rules are too far-reaching. In some cases, it's not just a matter of being deported, it's about ripping families apart and leaving children without one or both parents. As a result, it's important for families in Australia to take immediate action and understand the potential risks. Family members of offenders need to be aware of how these laws could affect them, too. Protecting your family from this kind of disruption means staying informed, understanding the legal landscape, and ensuring your rights are well protected. If you or someone you know has a family in Australia, it's crucial to take steps now to avoid being caught off guard by these life-altering changes. What do you think about the impact these laws have on families? Do you believe family unity should be prioritized over deportation? Share your thoughts with us in the comments. Your input is so important to us. And don't forget to subscribe. It's just one click to stay informed. Number 4. Deportation based on visa violations. One of the most startling changes under the 2026 deportation laws is the strict enforcement of visa violations. In the past, overstaying a visa or breaching visa conditions was something that could often be handled with a warning or a fine. However, under the new laws, even minor visa violations can now result in immediate deportation. This means that anyone who overstays their visa, even for a short period, or fails to comply with specific conditions, such as work restrictions or student requirements, could find themselves at risk of being sent back to their home country. These visa violations might seem insignificant to some. After all, many people have accidentally overstayed their visa without facing severe consequences in the past. But now, with the government tightening its grip on immigration enforcement, no one is safe. Even a few days overstay or a minor breach of a visa condition could trigger deportation proceedings. This is especially concerning for those who may not be fully aware of the changes or may have unintentionally violated their visa terms. What was once a minor issue is now a major threat to your stay in Australia. If you're in Australia on any type of visa, it's essential to stay on top of your visa conditions and expiration dates. The new laws make it clear: ignorance is no excuse. Whether you're a student, a tourist, or a temporary worker, keeping your visa status in check has never been more important. Even the smallest misstep could lead to deportation, and for many people, that's a reality they never saw coming. Have you or someone you know ever overstayed a visa or violated visa conditions? Share your thoughts in the comments. We want to hear from you. And if you haven't yet, subscribe to our channel for more vital updates. It's just one click. Number 5. Changes in deportation for refugees and asylum seekers. The new deportation laws also have significant implications for refugees and asylum seekers living in Australia. Historically, refugees seeking asylum were given some degree of protection under Australian immigration laws, even if they entered the country unlawfully. However, the 2026 changes now make it more difficult for refugees and asylum seekers to stay in the country.
Even those with valid claims for asylum may find themselves at risk of deportation if the government determines that they don't meet the new, stricter criteria. The law is shifting away from offering protection and is becoming much more stringent in dealing with refugees, especially those who have entered the country without proper documentation. This change means that many individuals who fled their home countries to seek safety in Australia might face the harsh reality of being sent back despite the dangers they fled. The new law does not just focus on the legality of their entry into the country, but also considers the circumstances under which they are staying. As a result, some asylum seekers who might have once been granted more time to prove their claims will now be facing expedited deportation proceedings. This has sparked concern among human rights organizations, which argue that the new laws could lead to unfairly deporting people back to dangerous situations. For refugees and asylum seekers, staying informed about the new changes is critical. It is now more important than ever to ensure that you are compliant with the strict immigration requirements. The risk of deportation is higher than before, and anyone in this vulnerable position should seek expert advice immediately to understand their rights and options. Do you think refugees and asylum seekers should face deportation under these new laws? Share your opinion in the comments. We'd love to know your thoughts. And if you haven't already, don't forget to subscribe to our channel. One click is all it takes to stay informed.
Number 6. Revocation of citizenship for dual nationals. One of the most controversial aspects of the new 2026 deportation laws is the revocation of citizenship for dual nationals. Under these changes, dual nationals, people who hold Australian citizenship alongside another country's, are now at risk of losing their Australian citizenship if they are convicted of certain serious crimes. In the past, Australian citizens, even those with dual nationality, were typically protected from deportation, no matter what offenses they committed. However, this law has upended that protection, creating a significant legal risk for individuals who hold dual nationality. This development has shocked many because it means that even those with long-standing ties to Australia, who may have lived here their entire lives, could be stripped of their citizenship and forced to leave the country. What makes this even more concerning is the broad scope of offenses that could lead to citizenship revocation. Convictions related to serious crimes, like terrorism, organized crime, or large-scale drug trafficking, could result in deportation, even for someone who was born in Australia. The government justifies this measure as a way to enhance national security, but for many, it's a harsh reminder that the security of citizenship can no longer be taken for granted. For dual nationals in Australia, this change means it's crucial to understand the full implications of these new laws. Your Australian citizenship could be at risk if you're involved in criminal activities, and losing that status would mean losing your right to live and work in the country. If you or someone you know holds dual citizenship, it's time to be extra vigilant about your legal rights and stay up to date on these potentially life-altering changes. What do you think about the revocation of citizenship for dual nationals? Should this be allowed? Let us know your thoughts in the comments below. We've put a lot of effort into creating this video, and we want to hear from you. Don't forget to subscribe for more updates. It's just one click. Number 7. Deportation for foreign students. The 2026 deportation laws also significantly affect foreign students in Australia. In the past, students were largely protected from deportation unless they committed major criminal offenses. However, under the new regulations, even a minor breach of visa conditions or local laws can now trigger deportation. For example, students who work beyond the hours permitted on their student visa or fail to maintain full-time enrollment are now at risk. What's more concerning is that these laws apply even if the violation was unintentional. Many foreign students might not realize how seriously these new laws are being enforced. Previously, if a student was caught working a few extra hours or accidentally failing to meet academic requirements, they could be given a warning. Now, those actions could lead to a swift deportation order. This new approach has raised concerns about the effect it will have on international students who contribute significantly to Australia's economy and cultural diversity.
With more stringent enforcement, students who may have spent years in the country planning their futures could find themselves suddenly forced to leave. If you're a foreign student in Australia, it's vital to stay on top of your visa conditions and academic progress. The risk of deportation has never been higher, especially for those who might not be aware of the stricter enforcement of these laws. Keeping track of your visa status and academic commitments can make all the difference in avoiding deportation, ensuring your stay remains uninterrupted. Are you a foreign student in Australia, or do you know someone who is? How do you feel about these new laws? Drop your comments below. We really want to hear your perspective. And if you haven't already, subscribe to our channel for more updates on laws that matter to you. It's just one click.
Number 8. Non-compliance with health and welfare requirements. Under the 2026 deportation laws, non-compliance with health and welfare requirements can now be a grounds for deportation in Australia. Previously, individuals who required significant government assistance or had health issues were often granted some leniency, but this is no longer the case. The new laws target those whose health conditions or reliance on public welfare are deemed excessive by the government. This could affect people who need regular health care, disability support, or other social services that go beyond what the government considers acceptable. For many, this change comes as a shock. Those with ongoing health issues, such as chronic conditions or disabilities, may now be facing an unprecedented risk of deportation if their needs are seen as placing too much strain on Australia's welfare system. The government justifies these measures by stating that they are trying to balance immigration policy with the nation's economic stability. However, this can result in discriminatory outcomes where individuals who are already vulnerable are forced to leave the country due to circumstances beyond their control. If you or someone you know is relying on government support or facing significant health challenges, it is crucial to understand how these laws could affect your immigration status. Those who rely on healthcare or welfare should be proactive about ensuring their situation doesn't put them at risk of deportation. Staying informed and seeking professional advice can be key to navigating this new landscape. Do you believe people with health conditions or those relying on welfare should face deportation? We'd love to hear your thoughts in the comments below. And don't forget to subscribe. It's just one click to stay up to date on laws that affect you. Number 9. Deportation of those with unpaid debts. One of the more surprising provisions in the 2026 deportation laws is the ability to deport individuals who have significant unpaid debts to the Australian government or legal system. In the past, having outstanding debts was a financial issue, but now it's tied to immigration status. If you owe money for taxes, fines, or legal penalties, you could be at risk of being deported, regardless of your contributions to the country. This includes debts that have been accumulating over time, even if you've been trying to resolve them. The Australian government is taking a tougher stance on financial responsibility as part of its broader immigration control strategy. It's now clear that the government views unpaid debts as a form of non-compliance that can undermine national laws and regulations. For people who have been living in the country for years, building their lives and careers, the idea that unpaid debts could result in deportation feels like a harsh reality. Whether it's unpaid fines for minor infractions or larger debts to the tax system, any outstanding financial obligations could now be grounds for deportation. If you're in Australia and have any form of unpaid debt, whether it's related to taxes, fines, or other financial obligations, it's time to take action. Clearing your debts can prevent the risk of facing deportation and can give you peace of mind moving forward. Understanding how these new rules apply to financial obligations is crucial in avoiding life-altering consequences. Do you think unpaid debts should be a reason for deportation? Share your opinion with us in the comments. We're eager to hear what you think. And make sure to subscribe. It's just one click to stay informed on critical legal changes like this.
Number 10. Public advocacy and legal challenges. As the 2026 deportation laws continue to stir controversy, public advocacy and legal challenges are becoming more prominent.
Many advocacy groups, human rights organizations, and even some lawmakers are speaking out against the sweeping changes, arguing that they're unfairly targeting vulnerable communities and undermining the core values of Australia's immigration system. These groups are fighting for reform, pushing for a system that doesn't prioritize deportation over the human rights of individuals and their families. As public backlash grows, legal challenges are expected to unfold in the coming years, potentially altering or even overturning certain provisions of the laws. For the general public, these developments are critical to follow, as they could shape the future of Australia's immigration policy. Legal experts and activists argue that the laws are overly broad, and the consequences for many could be devastating. The uncertainty surrounding how these laws will be implemented means that there could be significant opportunities for change if the right challenges gain traction in court. Understanding the legal challenges underway gives individuals affected by these laws a glimmer of hope as the fight for fairness and justice continues. If you or someone you know is facing the potential impacts of these deportation laws, staying informed about the legal battles is essential. Changes could be on the horizon, and public advocacy may lead to more protections for immigrants, refugees, and residents. It's vital to remain engaged and aware of how these legal challenges might shape the law in the coming months and years. What do you think about the public outcry against these new deportation laws? Do you believe the legal challenges will succeed? Let us know your thoughts in the comments below. We really value your perspective. And don't forget to subscribe to stay up to date on all the latest developments. Just one click.
As we've seen throughout today's video, the 2026 changes to Australia's deportation laws are far-reaching and life-changing for many people. Whether you're a permanent resident, a foreign student, or even a dual national, these new rules could have a significant impact on your future in Australia. From minor offenses to unpaid debts, the new criteria for deportation have raised concerns about fairness and the protection of individuals' rights. The changes are particularly concerning for families, refugees, and vulnerable groups who may face separation or return to dangerous situations if these laws are enforced. The wide scope of these laws makes it crucial for everyone living in Australia to stay informed and prepared. With deportation now a possible outcome for things that were previously overlooked or given leniency, understanding your rights and obligations has never been more important. If you or someone you know could be affected, it's time to take action to ensure you're not caught off guard by these sweeping changes. These new laws may seem daunting, but there is still hope. Public advocacy and legal challenges are in full swing, and it's possible that future changes could offer more protections for individuals. As the situation continues to evolve, it's important to stay engaged, keep track of updates, and most importantly, protect your rights. We've put a lot of effort into bringing you this important information, and we'd love to hear your thoughts. Comment below with what you think about these changes and how they might affect people in your community. If you haven't already, please subscribe. It's just one click to stay updated with critical information that can make a difference in your life. We appreciate your support.